while dealing with this idea and expressions, the question arises that whether all expressions and all expressions are copyrighted or not. Here, the more important perspective is of the doctrine of originality. So we have different doctrines of originality being developed at times in different jurisprudence, and basically we used to discuss three doctrines, that is of UK, US, and being in India, we discuss India. So what are all the doctrinal approaches? Because what creativity is there? How creative you are being there by making your particular expression is the most important thing while constituting the originality. Now, UK is sort of the bro theory. Now you understand, you have to be very clear about this originality. You have to be clear about how you have to be in this originality context. And while making some expressions, you have to be clear about this originality has to be at such a level and has to be at such a diligent level that it should constitute some originality in itself, and not in just in the form of an idea. The expression has to be created in such a sense that it has to be an original creation of the author. So while dealing with this originality, UK uses the sweat of the pro theory. While before discussing, I will discuss this case. This case comes up in the UK of University of London Press versus University Tutorial Press. In this particular case, what happened is that while dealing with this whole issue of originality context, University of London Press hired three professors, and those three professors took up the work of getting a question paper ready. The University London Press got the right and got the whole copyright over that particular work. And what they did is that those three professors tried to make a question, the performer of the questions, and while making the performer of the questions, they did their job. The University Tutorial Press took those questions. I think they took half of the questions and then published their own book. The University London Press claimed copyright infringement against the University Tutorial Press, stating that the questions that were being copied by the University Tutorial Press were being developed by the professors in the University of London. And since copying it without consent from the University of London by University of Tutorial, then it constitutes a copyright infringement. University Tutorial says that such a infringement cannot be there because these questions and these things are basically question of common type, and it is not a unique questions. So ultimately you cannot have a copyright over it. The court says that in spite of the fact that these questions are unique, the framing of the question requires some form of effort, some form of labor in it. That's why sweat of the brow. So some form of labor, if that particular work is expecting, and if that particular work holds some form of labor intellect, then ultimately the copyright will subsist in the plaintiff. So plaintiff was not denied the copyright, and the defendant was being charged by the copyright infringement. So ultimately, what sweat of the brow is that this doctrine explains us that when we try to deal with this originality context, and when we try to deal with such a context of originality in some artistic work, the labor and the intellect has to be taken account in. This was heavily debated, and in variety of cases, such a sort of the brow theory was also been negated. But as of now, if you want to understand this much only, that this doctrine explains that any work to be in context of original must require some labor and intellect in it, and that is how the originality context of sweat of the brow in UK came into existence after this case. Similarly, US, in the Feast publication was a ruler telephone. The case was that ruler telephone was a company which provided telephone services in a particular area. And in that particular area, what they did is that while getting into some services of telephone, they came up with a directory. That services that they provide in an area, they have a directory of phone numbers which they came out of that particular area. Feast publication was also getting into the domain of telephone services and also wanted to provide some directory. So Feast publication went to rural telephone to ask to ask for a license to use the directory that is being published by rural telephone. Rural telephone says that no, we cannot have. They denied the license to the Feast publication. What happened is that after getting denied for license, Feast Publication copied the rural telephone directory without their consent, and they hired some people. They investigate, and what they did is that after investigation they verified the data and they provided more information in the directory. Means the directory having name and number was not only having just two informations, but since it is verified, it is investigated, more information was given by the Feast Publication. Due to this more information being given, such a directory was becoming famous, became famous in that area. People started buying it because it is providing you more information. Then the rural telephone Feast Publication was claimed the copyright infringement by the rural telephone. Ruler said that the directory which he has or which they have maintained and which they have been publishing in the area has been copied by the Feast Publication. The US court in this case rejected the suit of the pro theory. They said that only the amalgamation of some data of that particular area people living and making a directory will not constitute a copyright over it, because rural telephone is doing nothing but they are just amalgamating and they are just collecting all the informations and making it in a book. While what Feast Publication is doing is that in spite of taking the directory also, they are working over it, they are investigating over it, they are verifying the data. So ultimately the Feast Publication and the Feast Publication is doing something, means modicum of creativity. They are providing some modicum of creativity in that sense, which provides more room and which provides more artistic or more creative nature of Feast Publication. The rural telephone was only collecting the data and inscribing it in a material form, but Feast Publication was doing more, like investigating and doing more. So US, while rejecting the suit of the bro theory, came up with this modicum of creativity. That creativity has to be there. So you understand the margin of originality in UK is very less, because it's only deals with the context of having a labor and intellect. While when you talk about US, it tries to talk about the creativity. It tries to talk about the creative in nature. So this domain and this margin of this originality context in both US, UK, and US are poles apart. Now India is in middle. It's not as lenient as UK and is not as typical as US. So it comes with a famous phrase of flavor of minimal requirement of creativity. The famous case of Eastern Book versus DB Modoc was is very important, whereby the famous we all know SCC and EBC. So they contended that the defendant was using their judgment and publishing it in their own form in CDs and in online format also, and providing it in a lesser prices, which is obviously the copyright infringement of Eastern Book. The defendant said that the judgments are there and they don't have any copyright. The Eastern Book doesn't have any copyright. What the defendant says, the court ruled that in spite of the judgments are there, the Eastern Book are working on those judgment, are working on those particular thing, are explaining in a more typical format, are suggesting and also are coming up with new format and new arrangement of such judgments, in which again they are doing creativity. So ultimately copying of those judgment by by the defendant of Eastern Book Company will constitute an infringement. So this also is very important because the particularly the court was totally tilted towards the US ideology of modicum of creativity, and inspired from US, tried to deal with such a case that okay, even if it is being copied, the Eastern Book is doing something. In Eastern Book is what you say creativity, a minimum requirement of creativity is being done by Eastern Book, and hence they constitute copyright in which, and copying of such a thing will constitute a copyright infringement.